សូមជើញគូចចុះសូមជើញសហគ្រាសរងឡើងទៅសេចក្តីសន្តានបន្តទៀតលោកនៅសល់25នាទីទៀត
Thank you, Your Honours. Your Honours, I submit that my submissions today won't be as expeditious as the learned International Council and National Council, and they won't have as much flair. But I hope my submissions will convey more completely the fairness or the accuracy of what is required in terms of translations in the defence case. The prosecution joins with the defence, of course, in ensuring that this trial for the accused or the charged person, that it would be expeditious, or this process would be expeditious and fair. If a process is only expeditious, then the legality of the proceedings would be undermined. In terms of fairness, then, it really is a question of what is fair for this charged person, what is fair for this defence team in terms of being able to understand the case that's been alleged against them, or the investigation that involves him. That's a little more complicated or a little more complex than our learned counsel has put forward today. In short, the defence's position is that every document, every line of every document in the case file, no matter how large, must be in the language of the native language of the International Co-Council. It's submitted here, Your Honours, that that is not appropriate. That has never been held to be inappropriate in any other court when Your Honours look at the jurisprudence, and we have identified that during our brief, in our brief. And secondly, it's not required, and it's largely not required because of the nature of this system and the systems that operate at the other tribunals. And that's a system of a joint defence team with multiple languages, with collaboration. And as a result of that, and as a result of the complexity of these cases, all of the courts have said collaboration is required in the defence, and not every counsel, nor even every accused, needs to necessarily be able to read every document that may be used against him, but he must understand it. And that's quite a different distinction. And to understand, of course, the defence counsel, as with the prosecution and as with the chamber, everyone has an obligation to collaborate, to maximise their skills, to ensure that each of our different roles are fulfilled. Your Honours, I will make 3 points. The first being that this charged person has all the documents he's entitled to in a language he understands. Secondly, the defence team, including the International Co-Council, is able to effectively represent the charged person. And thirdly, I won't address this point specifically, but if Your Honours found that there was any sort of violation or abuse of process, that the remedy certainly is not releasing this defendant. However, that's not the prosecution's position. The prosecution's position is that the order is legally justifiable and quite appropriately reflects the rights of the accused or the charged person to having a fair trial. I'll first briefly mention a point raised by my colleague about what it means, the term the working languages of the tribunal. You've heard the defence state in their written pleadings that working language means that every document must be translated in English, Khmer and French. That's not correct. The practice direction shows that that's not correct. 7.1 of the practice direction states that documents only need to be filed in Khmer and one other official language, not two others. Similarly, this issue has been tested, of course, at other tribunals that have faced the issues that you're facing today, and it's been held that working languages mean something other than the translation of every document into the three. If we look at the Yugoslavia tribunal that has the same working languages, French and English, the Delalic decision, which was confirmed in the case of the Zaric decision at that court, held that implicit in the concept of working languages is that all papers which are filed with the international tribunal be in either English or French, not both. Your Honours, the law that relates to translation rights in these types of cases at other tribunals of similar complexities, as my learned colleague has said, relates more to the rights, or is focused more on the rights of the accused rather than the rights of counsel. And it's important, therefore, to ensure, in terms of a right to a fair trial, that the rights of the accused are upheld. Based on the international case law dealing with similar cases, during the pre-trial stage, whether it be in a civil system, a judicial investigation, or with a hybrid system of civil and common law, like at the other tribunals, where it's a prosecution-led investigation, the rights are similar. An accused is entitled to, when Your Honours look at the jurisprudence, a copy of, and at most, the introductory submission in the civil system, the notification of the charges, the indictment, the supporting material accompanying the indictment, the statements of all the witnesses that the prosecutors intend to call at trial, discovery material that's in the language of the accused, exculpatory material, and written decisions and orders. This list, or this composite list, taking into account the different systems, was first determined at the ICTY in the case of Lubicic and was later upheld in the case of Sechel. The pre-trial chamber of the ICC in the Lubanga case agreed with the ICTY when it ruled that an accused is not entitled to have all procedural documents and evidentiary materials translated into his language. The ICC held that the only evidentiary materials the prosecution is expressly required to translate are statements of prosecution witnesses. In the Lubanga decision, the court at the ICC, they considered the European Court of Human Rights jurisprudence on translation rights, including Ludicki and Kamasinki, which the defence cites in their appeal, and declared that nothing more than the above list was required. Our sister tribunals have held that providing a defendant with an interpreter is an adequate substitute for procuring the translation of certain documents in a language he understands. The ICC in Lubanga held that free assistance of an interpreter and translations of specified documents meet the requirement of fairness. This decision was upheld in the case of Chow. In the Rwanda tribunal, in the case of Muhimana, it stated that if the registry had difficulty translating documents, it could have them orally interpreted to enable the defendant to get a gist of its contents. Therefore, according to international tribunal jurisprudence, At the pre-trial stage, which is similar to the stage at this court, only certain documents must be translated into the language of the accused, and the provision of a translator to assist the accused to adequately protect his right to a fair trial. If we look at the case of this charged person to see exactly what he has received, to see if it fulfills that test of what he's required to receive in order to ensure that at this stage that he has the ability to have a fair trial. And my learned colleague has correctly pointed out that this translation order is not a final order, it's a progressive order that understands the nature of where the proceedings are, but also understands it's an order, or the rights of this charged person will change over time. They will change as he approaches the trial, and they will change when he's in trial. The appeal is about the appropriateness of this order, not about ultimately what he's required to receive at trial. Your Honours, in accordance with the jurisprudence, this charged person already has the translation of all documents necessary to protect his fair trial rights and prepare an adequate defence at this stage. In addition to, and including what is required by the order and law, he has been given the following documents in all three languages: Khmer, English and French. He's been provided with the introductory submission, which is the primary document notifying the charged person of the legal and factual nature of the offences alleged against him. This is a comprehensive submission of over 100 pages, 55 of those being footnote references to the exact page in the evidence that supports that submission. That has been provided in Khmer, French and English. He has been provided with a detailed list of witnesses categorised according to the factual and legal elements they have knowledge of and could be expected to provide testimony on. This list, entitled Annex B to that submission, is 96 pages long, and it's in Khmer, French and English. He has been given a detailed set of 105 schedules comprising of over 1,200 evidence summaries of fully referenced statement excerpts from the introductory submission supporting material. Each reference, each excerpt, indicates the exact page or pages in which the evidence can be found in the original document. These schedules total 206 pages. Those schedules have been provided in Khmer, French and English. He has been provided with a document index entitled Annex C, which is a complete reference of every one of the 1,039 documents supporting the introductory submission, covering 55 pages. It contains all the identifying information for each supporting document, including a brief description of its contents and an opinion as to which aspect of the case it assists in proving. This annex, with corresponding electronic documents attached, has also been provided in a sophisticated analytical program allowing for an easier and faster understanding of the submission and the documents. Those documents have been, that index has been provided in Khmer, French and English. Your Honours, in relation to the introductory submission, it totals 616 pages of various levels of analysis of the introductory submission. It describes in Khmer, French and English in detail the prosecution case theory and the legal and factual elements of the case supporting the allegations against the charged person. This information allows equally the charged person and every member of the team, the defence team, the ability to understand comprehensively the evidence against him and therefore prepare his defence through the judicial investigation phase at this stage. The supporting documentation that supports the introductory submission, these 1,039 documents, 83% are in Khmer, a language the accused can understand, 10% are in French, another language he can understand, and 7% are only in English. There is more English, but 7% are only in English. That's as of 2 days ago. As the defence have said, Khieu Samphan is proficient in Khmer and French. Over 93% of the documents are in a language that the charged person can understand. Therefore, regarding the introductory submission, with all of its supporting material, the branches of this court have ensured that even during the pre-trial stage, the charged person can easily understand the allegations against him. The remaining part of the case file, which is the judicial investigation that's happened since, contains about 2,683 documents, not the 60,000 documents my learned friend was referring to. I think he may have been referring to pages. But the 2,683 documents, 60% are in Khmer, and combined with French, about an extra 25% are in French, meaning that 85% of these documents are in a language that the charged person can understand. It'll be submitted in a moment. The charged person can also understand English to a certain level. If we look more closely at the investigation and look at the statements by the co-investigating judges, they've taken 194. 99% are either in Khmer or French. In fact, the translation reflects a policy of the OCIJ that as a matter of course, all of the statements taken from witnesses will be translated into all three languages. Your Honours, Khieu Samphan, through his counsel, in a document numbered C26I22 at paragraph 12, states that Khieu Samphan only understands Khmer and French. However, he seems to have a proficiency in English. A press conference in 1998 is one example of where it shows that he has a reasonable command of English. And I would just ask that the AV booth can play just a short segment of that video showing the proficiency of this charged person in English, at least to a certain level. If I can ask that that could be played now. Your Honours, this is a clip from 1998.
លោកមេធាវីដែលលោកចង់មានសារអីបាទលោកចង់មានខ្ញុំបាទណែសូមអរគុណលោកប្រធានអង្គបរិយាជំនុំជម្រះខ្ញុំចង់ជំទាស់នឹងការស្នើសុំឲ្យចាក់ពីព្រោះណែលោកខៀវសំផនគាត់ចេះតែថាខ្លួនគាត់នឹងថាជាអ្នកដឹកនាំប្រជារដ្ឋកម្ពុជាប្រជាធិបតេយ្យនឹងមានតែឈ្មោះមានតែខ្លួនគាត់ខំនិយាយអង់គ្លេសហើយយើងយកថាជាភ័ស្តុតាងថាគាត់ចេះអង់គ្លេសខ្ញុំមានដើរជាមួយអ្នកមិត្តភ័ក្តិនៃគេត្រូវនិយាយភាសាអង់គ្លេសហ្នឹងគេខំមើលក្នុងបន្ទប់ដើម្បីថាគេចេះអង់គ្លេសប៉ុន្តែមិនលោកខៀវសំផនឥឡូវហ្នឹងសូមលោកប្រធានមេតាសួរគាត់ផ្ទាល់ទៅបើគាត់ថាគាត់ចេះអង់គ្លេស juridic នោះពាក្យសុំទោសគាត់ចេះអង់គ្លេសភាសាច្បាប់បើថាគាត់ចេះមែនអាហ្នឹងសូមចាក់ចោះសូមទោសខ្ញុំសូមតែប៉ុណ្្នឹងនេះអត់សូមប៉ុណ្្នឹងអរគុណលោកអង្គបរិយា
même ça.
Monsieur Sampan n'improvise pas. Il a un texte que d'autres ont écrit et il est en train de le lire. Alors on peut inférer de là qu'il parle anglais comme un étudiant d'Oxford, mais c'est une interprétation un peu exagérée.
Your Honours, perhaps if I can just briefly mention, I know there's a shortness of time, and of course if the video is played, it would take up some of that time. If I could ask Your Honours at some point if you could review that video, it's been placed on the case file, and make Your Honours' own opinions as to his proficiency in English, unless Your Honours would like it played right now.
It's the pre-charge chamber's understanding that it is in the case file and that you make reference to the document in the case file, and you ask the pre-charge chamber to pay attention to that reference.
Thank you, Your Honour.
That's understood.
Great. And just to be clear, Your Honours, the prosecution are not saying that Mr. Q Sampan is fluent in English at all. We're just saying there's a level of proficiency that should be taken into account when determining whether, as a defence team, they have an ability to read or deal with English documents. If perhaps now if we move to the right that might attach to a co-counsel, such as the International Co-Counsel. Again, the prosecution submits the rights to translation largely concentrate on the rights to the accused. However, defence counsel that don't speak, that require documents in their native language, there are some rights that apply to them. In the Muhammana case before the Rwanda Tribunal, the defence counsel, who was only conversant in French, requested to have materials disclosed by the prosecution in French and to have the registry ensure free translation of materials. After detailed consideration, the tribunal said 2 types of documents should be translated as a result of that request, English and French, in English and French, the party submissions, secondly, the evidence that would be adduced at trial. However, regarding all other documents, the court hoped that through fruitful collaboration, the defence team would work together to understand the contents of the documents. Similarly, in the Lubicic case, the Yugoslavia Tribunal held that although the defendant could not understand all the documents in the case, at least one of the defence counsel is presumed to be fluent in one of the official languages of the tribunal and should be capable of fully participating in the proceedings. Like Lubicic's defence team, the Q Sampan defence team consists of 2 attorneys which are fluent in at least one working language of the court. Therefore, Q Sampan's team is competent to fully participate in the proceedings and present a reasoned and adequate defence. As of right, therefore, in terms of evidentiary documents at this stage, there is no entitlement for the International Co-Counsel to receive documents in the language of his choosing at this stage of the proceedings based on international jurisprudence. However, any documents that he thinks he may wish to put in evidence could be requested to be translated. As a trial may approach, nonetheless, the International Defence Council, based on this jurisprudence, could receive translation of the evidence adduced at trial in 2 languages. In light of the unique rules at the ECC, this evidence would not be everything that's in the case file, but it would likely be a subset determined by the parties through their Rule 79.9, where it requires the parties to provide exhibit lists, and the trial chamber's lists of evidence it would like to put before the parties either in full or a summarised form pursuant to Rule 87.2. However, the assessment of the extent of that right would need to be taken into account many factors which are more easily and appropriately addressed at the trial stage of the proceedings. Your Honours, if I can ask to have 10 further minutes to finish, that perhaps might be an extra 5 minutes that was originally provided to complete the submission. Your Honours, I'd like now to turn to the duty or the obligation of the defence to cooperate with the organs of the court. The defence argue that this court is required to exercise due diligence in the conduct of proceedings, particularly where the charged person is in provisional detention. We submit it has. The Office of the Co-Investigating Judges, the Defence Support Section, the Court Management Services and the Office of Administration have worked tirelessly day in and day out to move forward with this investigation. Conveniently, the defence neglected to mention the duty upon themselves to cooperate with the organs of the court. Article 21.3 of the ECC agreement states that any counsel, whether Cambodian or not, engaged or assigned on behalf of a suspect in the defence of his or her client must act in accordance with the present agreement, the Cambodia law on the statutes of the bar, and recognise standards and ethics of the legal profession. All national jurisdictions have rules governing the conduct of lawyers that require them to act in an ethical, responsible and professional manner. In the ECC multilingual environment, the duty includes working diligently as a team to represent the client. Your Honour recognised this in your adjournment order on the 23rd of April 2008, when you stated linguistic and legal issues may be fully addressed by a team of lawyers representing a charged person. The alternative, of course, is if such collaboration with a team is not possible, is for the charged person to make a request for a new lawyer to represent him. This sentiment represents the jurisprudence of the Rwanda Tribunal, which stated that through fruitful collaboration, one counsel would be able to help the other to understand the contents of the documents. In the Katanga case, the pre-trial chamber at the ICC stated, it's the responsibility of permanent counsel to compose the defence team in a manner which will allow him or her to be properly assisted in the presentation of the case and effectively protect the rights of the accused. At the ICC in the Lubanga case, they also emphasised that the defence should choose a team that takes into account language skills in order to effectively represent the defendant. Therefore, this defence team, these counsel have an ongoing affirmative duty to work with the other members of the defence team to pursue his or her client's interests. Defence counsel cannot use the translation issue to attack this court if they do not take reasonable measures to address translation needs. This charged person contends that the translation order seeks to shift the equality of arms by placing the burden of translation on the defence team and away from the state. The prosecution states far from it. The translation order provides them with a translator of their own choosing to fulfil any gap in language requirements, of which up until this date, 6 months after the order has passed, they have not accepted. And secondly, the translation order has invited the defence team to provide lists of documents they think they would like translated, and to this date they have not provided one list, one document for the CMS to translate. By providing a translator to each team, the co-investigating judges did not shift the burden, but they supplemented the defence existing linguistic capacity to further enhance the charged person's right to a fair trial. The defence had the ability to cooperate. Q Sampan's former and current lawyer speak Khmer and French, that's Mr Soibori and Mr Sarsavan. The charged person speaks French and understands, at least outside of the court, his ability to work in English through collaboration. I ask Your Honour to, for the shortness of time, I ask Your Honour to look at A190I4, ERN number 0022-1279. Perhaps if we can show it on the screen, but it's a record from the Paris Bar showing that Mr Vergès presents himself as a lawyer, an international lawyer that can work in the language of English. It doesn't necessarily state that he speaks English perfectly, but it shows that he can work in that language. Your Honours, I would ask that you refer to that in the case file. The charged person defence team also employs Mr Seng Sachita, who studied in France and speaks. The charged person's defence team also employs another Cambodian jurist, Mr Seng Sachita, who speaks French and Khmer and English. The defence team is comprised of other lawyers that speak the three languages. Your Honour, therefore, nothing prevents the charged person from requesting translation from CMS. However, over the past 6 months, as I've stated, not one translation has been requested. Your Honour, the translation order is not tailored for the defence, but it's aimed at all of the parties. The duty to collaborate in this judicial process is placed on all actors within the ECC. All parties are affected by not having some documents in their own native language, but they can ably and adequately cope by a process of collaboration. If Your Honours look at the screen now, you'll see the page for Mr Vergès from the Paris Bar, and he advertises himself as being able to work in English. Thank you. Your Honours, in a multilingual environment such as this court, we all have to be adaptable so we can meet our obligations in our respective tasks. Taking a conscious decision to opt out of a collaborative process like this defence has chosen to do has the effect of undermining their own clients' rights. Your Honours, I would like now to pass over the floor to my colleague who has 1 minute to close on behalf of the prosecution.
សូមអរគុណដោយសារនេះអ្វីដែលយើងខាងសហប្រញ្ញាបានអធិប្បាយកន្លងមកនេះគឺថារយៈពេលវាយូរហើយដូច្នេះខ្ញុំអត់មានអីវែងឆ្ងាយទៀតទេគឺមានតែការស្នើទៅអង្គបរិយាជំនុំជម្រះនៅការសន្និដ្ឋានចុងក្រោយសហប្រញ្ញាគឺស្នើសូមឲ្យអង្គបរិយាជំនះបដិសេធចោលនៅបណ្ដឹងឧទ្ធររបស់សហមេធាវីការពារក្តីពេលនេះនៅបណ្ដឹងឧទ្ធរនេះចោលដោយយល់ឃើញថាទី1បណ្ដឹងឧទ្ធរនេះនៅក្នុងវិធានផ្ទៃក្នុងគឺមិនអាចទទួលយកបានទេទី2យល់ឃើញថាសិទ្ធិរបស់ជនត្រីចោទហ្នឹងមិនត្រូវបានបាត់បង់ឡើយទី3ដោយយល់ឃើញថាគ្មានយុទ្ធសាស្ត្រតុលាការអន្តរជាតិណាមួយដែលធានាថាគ្រប់ឯកសារទាំងអស់ដែលនៅក្នុងសំណុំរឿងត្រូវបានបកប្រែទៅជាភាសាសហមេធាវីការពារក្តីនោះទេចាខ្ញុំសូមសំណូមពរមានតែ3ចំណុចហ្នឹងសូមអរគុណលោកមេធាវីការពារជនត្រីចោទមានមតិអ្វីដែរចំពោះការសន្និដ្ឋានរបស់
ខ្ញុំសូមអរគុណលោកប្រធានសូមគោរពអង្គបរិយាជំនុំជម្រះសូមគោរពមហាជនដែលបានស្ដាប់ខ្ញុំសូមលោកប្រធានមេត្តាឲ្យមនុស្សខ្ញុំដើម្បីខ្ញុំបាទនាទីសម្រាប់ឆ្លើយ5នាទីសម្រាប់ឆ្លើយ15ដល់10បាទអូខ្ញុំមិនប្រើដល់អស់ទេពីព្រោះតាមដែលស្ដាប់មកលោកសហព្រាញ្ញានឹងនិយាយមានប្រសាសន៍ច្រើនជាងប៉ុន្តែដើម្បីគោរព15នាទីនេះណែខ្ញុំសូមចេះសូមកត់សម្គាល់ថាការនេះបកស្រាយសូមឲ្យបកប្រែឯកសារណាដែលពាក់ព័ន្ធនឹងដាក់គុកកូនក្តីខ្ញុំព្រោះតាមដែលខ្ញុំស្ដាប់មកនោះឮតែសូមបកប្រែភាសាបកប្រែមកជាភាសាខ្មែរខ្ញុំសូមបញ្ជាក់អង្គបរិយាជំនុំជម្រះថាសូមបកប្រែតែឯកសារណាដែលដាក់គុកគាត់ពីព្រោះតាមខ្ញុំចាំមិនដឹងគេខាងណាទេទៅយកឯកសារច្រាវសាវជ្រាវលោកយកឆាងលះផ្ទះដៃព្រឹបយកមកដើម្បីយកមកចោទប្រកាន់ដូច្នេះបានសេចក្តីថាខ្ញុំគ្មានឧបករណ៍ណាស្មើនឹងសហបរិញ្ញារឿងនេះខ្ញុំគ្មានគោលបំណងថាសូមបកប្រែនេះឲ្យវាយឺតយ៉ាវអស់ថវិកាគឺថាលកឹកណាមិនបានបកប្រែឯកសារណាដែលពាក់ព័ន្ធនឹងការដាក់គុកបណ្ដោះអាសន្នគឺខ្ញុំសូមម្ដងថ្ងៃនេះឥឡូវនេះសូមតែឲ្យចេញអំពីបណ្ដោះអាសន្ននឹងមកចាំអីដាក់គុកមិនចាំឲ្យអង្គបរិយាជំនុំជម្រះសម្រាប់រឿងនេះសិនតែដាក់គុកទៀតហើយថ្មីទៀតថែមមួយឆ្នាំទៀតបានអីដាក់2ខែអញ្ចឹងទៅដើម្បីឲ្យវាឃើញរូបភាពថាកន្លែងនេះខ្ញុំអត់លេងល្ខោនទេខ្ញុំសូមថាគោរពច្បាប់បើឲ្យលេងល្ខោនអញ្ចឹងទៅខ្ញុំមិនបាច់មកនិយាយច្បាប់ទេណែនេះជាចម្លើយមួយមិនមែនមានលក្ខណៈចង់ពញាពេលទេពញាពេលយូរទៅកូនក្តីខ្ញុំហិតទៅវេទនាទៅទៀតចម្លើយមួយទៀតមុននឹងខ្ញុំជម្រាបអំពីសុំឲ្យអង្គបរិយាទទួលបណ្ដឹងតមួយទៀតនោះគឺថាមិនត្រូវទទួលបណ្ដឹងតខ្ញុំសុំឲ្យបកប្រែពីព្រោះមិនបានចែងខ្ញុំសូមរំលឹកឡើងវិញថាថ្ងៃ14ខែកុម្ភៈ2008លោកសហមេធាវីអន្តរជាតិលោករ៉ាវីសេបានសុំទៅសហចៅក្រមស៊ើបសួរថាសូមឲ្យមេត្តាចាត់វិធានការណាឲ្យសមស្របនឹងការស៊ើបអង្កេតលោកសហចៅក្រមបានទទួលពាក្យការសុំនេះដូច្នេះវាជាអំពើមួយស៊ើបអង្កេតហើយលោកបានឆ្លើយទៀតថាមិនឲ្យបកប្រែរាល់សេចក្តីសម្រេចរបស់សហចៅក្រមដែលជាអំពើនៅក្នុងនីតិវិធីស៊ើបអង្កេតគឺថាអ្នកណាក៏អាចប្តឹងឧទ្ធរបានដែរដូច្នេះខ្ញុំសូមឆ្លើយថានេះគឺការភ័ន្តច្រឡំមិនតាំងពីនោះសហបរិញ្ញាថាចេះទៅទៀតថាការដែលសុំនឹងវាចូលទៅក្នុងនៃវិធានការរដ្ឋបាលខ្ញុំថាមិនមែនទេបន្ថែមលើនឹងទៅទៀតលោកអៀងសេរីសុំឲ្យបកប្រែទៀតសហចៅក្រមដដែលនឹងទទួលពាក្យនឹងទៀតអានោះខ្ញុំមិននិយាយទេប៉ុន្តែអ្វីដែលគួរឲ្យសោកស្ដាយលើសនោះគឺសហចៅក្រមស៊ើបអង្កេតហ្នឹងគាត់មិនមែនត្រឹមតែមិនឲ្យទេគាត់ថែមឲ្យអត្ថន័យប្រកបកតបកិច្ចណាកតបកិច្ចនិងករណីយកិច្ចរបស់អ្នកសុំបកប្រែឲ្យខ្ញុំដឹងឲ្យមិនកើតខ្ញុំយកឧទាហរណ៍មួយព្រះអាជ្ញាចោទប្រកាន់ថាលោកខៀវសំផស្សឧទាហរណ៍ទេថាលោកខៀវសំផស្សបានខົບខិតកាប់ស្លាប់គេមានសាក្សីម្នាក់ប៉ុន្តែខ្ញុំនេះដែលការពារគាត់ខ្ញុំត្រូវរកសាក្សីថាថ្ងៃដែលកាប់ស្លាប់ម៉ោងនេះលោកខៀវសំផស្សកំពុងតែទទួលម្ហូបបាយឲ្យខ្ញុំរកមិនកើតពីព្រោះគាត់ដាក់មកឲ្យខ្ញុំគឺដាក់តែបន្ទុកព្រោះខ្ញុំចង់ដឹងថាបន្ទុកនោះស្អីខ្លះបកប្រែអស់ឬតែនិយាយសមាមាត្រ60%ប្រមាណ%ចុះក៏ណែលោកព្រះអាញាសហព្រះអាញាក៏ខំហ៎ 100% ទៅព្រោះនេះគុកច្បាប់ណាឃើញជាប់គុកទៀតទេហ្នឹងហើយហើយកុំឲ្យខំពេកហ្នឹងហើយហើយសុំលុយគេទៅបងឥឡូវខ្ញុំសុំសង្ខេបខ្ញុំសុំវិលមកវិញថាខ្ញុំសុំឲ្យអង្គបរិយាពិចារណាលកឹកណាណែខ្ញុំសហមេធាវីមិនបានឯកសារដែលពាក់ព័ន្ធនឹងកាច់ដាក់គុកគាត់ហ្មងនិយាយខ្លីមិនមែនទាំងអស់ទេហ្នឹងហើយលកឹកណាមិនបានអញ្ចឹងទេតុលាការយើងមិនបាន ណែយុទ្ធធរទេកាត់ស្គែហើយខ្ញុំក៏សូមអរគុណនៅលោកសហប្រញ្ញាថាខ្ញុំទាំងអស់នេះទាំងពីរនាក់នេះសូមតាសហការជាមួយលោកប្រញ្ញាដើម្បីរកអីថាដើម្បីរកការពិតបើកូនក្តីខ្ញុំគាត់កាប់គេទាំងអស់ខ្ញុំអត់មានធ្វើឲ្យគាត់សសុំទោសគេទៅខ្ញុំប្រាប់បើគាត់កាប់គេស្អីរកឲ្យឃើញទៅរួចសុំទោសគេទៅខ្ញុំអត់មានធ្វើឲ្យគាត់សទេប៉ុន្តែខ្ញុំសូមអង្គបរិមេតាស្វែងរកការពិតកុំឲ្យមានការជ្រៀតជ្រែកនយោបាយនៅក្នុងអង្គបរិយាជំនុំជម្រះនេះដូច្នេះដើម្បីនឹងសង្ខេបទុកឲ្យសហមេធាវីខ្ញុំសូមឲ្យលោកប្រធាននិងអង្គចក្រមទាំងអស់និងសហប្រញ្ញាមេត្តាបញ្ញាឡើងវិញទទួលបណ្ដឹងអូតូខ្ញុំសូមមេត្តាអរគុណ
សូមអញ្ជើញលោកវេស
On vous a communiqué toutes les pièces à charge. Bien sûr. Mais les pièces à décharge, elles sont dans le lot qui n'a pas été traduit. Et on nous dit choisissez les documents que vous voulez. Mais comment pouvons-nous traduire ces documents si on nous les interprète, s'il n'y a pas d'interprétation, de traduction? Donc c'est se moquer de nous. Prenez dans ces documents que vous ne pouvez pas lire les pièces qui vous conviennent. Nous, on vous communique tout ce qu'on a fait contre vous. C'est une plaisanterie. Maintenant, on cite la procédure des tribunaux pénaux internationaux. Je crois qu'on se moque de vous. Moi, je ne parle pas d'après des jurisprudences écrites, je parle d'après une expérience personnelle. Pardon? J'étais présent au procès de Milosevic. L'instruction se faisait à l'audience. Quand il y avait un témoin qui était entendu, qui devait témoigner contre lui, ce témoin venait à l'audience. On le découvrait à l'audience. Et Milosevic était prévenu 15 jours avant de cette audition. Alors qu'on ne nous dise pas opposer la jurisprudence des tribunaux pénaux internationaux à celle de la vôtre. Là-bas, nous sommes dans une procédure accusatoire. Ici, nous nous réunissons sur les bases d'un document réalisé par le juge. Et on nous dit collaborer. Mais nous sommes prêts à collaborer. Mais qu'on nous en donne les moyens. Maintenant, si on passe à la menace de sanctions, alors je dis, je porte une robe qui est digne et je ne porte pas le gilet d'un valet de chambre. Et prenez vos responsabilités, monsieur le procureur. Moi, je ne suis pas le domestique de personne. Et je ne crains personne. Vous voulez parler de sanctions? Prononcez-les. Faites des réquisitions tout de suite. Et je rentrerai à Paris, tous mes confrères m'applaudiront de n'avoir pas trahi ma charge. Vos menaces, je m'en moque.
Soom អរគុណលោកប្រធានសូមតា1មីនិតទេទៀតសូម1មីនិតខ្ញុំសូមឆ្លើយនឹងសហមេធាវីសូមទោសសហព្រះអាជ្ញាណែអន្តរជាតិពីព្រោះខ្ញុំមើលមុខទាំងអស់ទៅខ្ញុំអាយុ68ឆ្នាំខ្ញុំមានពិសោធន៍នៅក្នុងច្បាប់35ឆ្នាំនៅប្រទេសបារាំងនៅខ្មែរខ្ញុំមិនដែលឮសហចក្រមណាបដៅខ្ញុំអំពីកាតព្វកិច្ចមេធាវីនិងករណីកិច្ចមេធាវីនៅក្នុងនេះសិទ្ធិមេធាវីទាំងអស់លើកទី1ថ្ងៃ4នេះសហប្រញ្ញាបរទេសឲ្យខ្ញុំគោរពកាតព្វកិច្ចនិងករណីមិនចេះធ្វើការប៉ុន្តែខ្ញុំសូមទោសខ្ញុំថាខ្ញុំជាមេធាវីទោះបីខ្ញុំមានការតិចទៀននឹងបរិយាញ្ញាក៏ដោយខ្ញុំមិនហ៊ានឲ្យអនុសាសន៍ទេប៉ុន្តែខ្ញុំចង់ឆ្លើយថាគាត់មិនដឹងរៀននៅសាលាណាទេសូមទោសអរគុណ
បាទសូមអញ្ជើញជនត្រូវចោទលោកខៀវសំផនបាទជួយមកកាន់នៅមុខតុលាការហើយសូមនិយាយសម្ដីចុងក្រោយសំណុំពរចុងក្រោយរបស់លោកលោកខៀវសំផនសូមអញ្ជើញក្រោកឈរបាទលោកមានសំណុំពរអ្វីជាសម្ដីចុងក្រោយរបស់លោកចំពោះតុលាការ
បាទលោកមេធាវីទាំងពីររបស់ខ្ញុំ បាននិយាយគ្រប់គ្រាន់អស់ហើយគឺថាក៏ត្រូវការយល់ដឹងឯកសារឲ្យបានច្បាស់លាស់ល្អិតល្អន់ទើបក៏មានលទ្ធភាពការពារខ្ញុំបានហើយតើខ្ញុំវិញខ្ញុំបានពិនិត្យខ្លួនឯងសារចុះសារឡើងចិត្តអស់មួយជីវិតខ្ញុំនេះហើយខ្ញុំមិនពិនិត្យទៅមានតែខំប្រឹងខំប្រែងដើម្បីការពារអធិបតេយ្យភាពជាតិរបស់ខ្ញុំឯករាជ្យជាតិរបស់ខ្ញុំហើយស្រាប់តែមកដល់ពេលនេះខ្ញុំត្រូវចោទទៅជាបានប្រព្រឹត្តអក្រិតកម្មប្រឆាំងមនុស្សជាតិអក្រិតកម្មសង្គ្រាមអានេះដែលខ្ញុំមិនយល់សោះហើយឯកសារខ្ញុំរឿងខ្ញុំបើខ្ញុំមានឱកាសនិយាយជំរាបតុលាការនឹងឃើញថាវាងាយសោះហើយខ្ញុំឆ្ងល់វាហេតុម៉េចបានតែជារាប់ពាន់រាប់រយចំពោះរាប់ម៉ឺនទំព័រមកហើយខ្ញុំឃើញដំបូងខ្ញុំខំអានខ្ញុំខំកត់ត្រាការកត់សម្គាល់របស់ខ្ញុំរហូតដល់អ្នកយាមនៅកន្លែងមន្ទីរឃុំឃាំងក៏ថាមកពីខ្ញុំនោះខំសរសេរពេកខំអានពេកបានខ្ញុំធ្លាក់ខ្លួនឈឺហើយអ្នកនាំពាក្យតុលាការក៏បាននិយាយដូចគ្នាចឹងដែរឮសូរថាគាត់សរសេរច្រើនពេកអានច្រើនពេកបានតែធ្លាក់ខ្លួនឈឺមកពីអីមកពីខ្ញុំឃើញថាឯកសារនេះវាមិនដឹងយ៉ាងម៉េចទេបើតែជាចឹងខ្ញុំវាឆ្ងល់មហាសែនឆ្ងល់ឥឡូវនេះខ្ញុំត្រូវងើបពីឈឺបានច្បាស់លាស់ផងខ្ញុំនិយាយមិនបានច្បាស់ផងហើយការគិតគូររបស់ខ្ញុំវាមិនបានជ្រៅជ្រះហើយមកចាត់ផងទេឥឡូវនេះបើប្រសិនជាមេធាវីខ្ញុំថាមេធាវីខ្ញុំទាំងពីរយល់ឯកសារមកគ្រប់គ្រាន់ខ្ញុំមានជំនឿជឿជាក់ថាខ្ញុំអត់មានត្រូវមានទោសអីទាំងអស់ហើយខ្ញុំមានជំនឿជឿជាក់ថាខ្ញុំអត់មានមកជាប់ឃុំឃាំងដល់ថ្ងៃនេះទេសូមទោសតុលាការសូមជូនយោបល់តែប៉ុណ្ណឹង
ចឹងតុលាការបញ្ចប់សវនកម្មប្រធានកងការពារនាំជនទៅចោទទៅកាន់មន្ទីរឃុំឃាំងសូមប្រកាសបញ្ចប់សវនកម្មសូមជម្រាបសាធារណជនថាសាធិការស្ដីអំពីសវនកម្មយើងនេះយើងនឹងជូនដំណឹងនៅពេលក្រោយបាទ
Alo បាទខ្ញុំសូមជម្រាបតិចអ៊ំពូមីងដែលមកតាមឡានក្រុងបាទសូមអញ្ជើញទៅចាំនៅខាងឡានក្រុងបាទ